And when people get named as executor, usually it's mom or dad or a friend goes, hey, would you be my executor? And they go, yeah, sure, no problem.
Welcome to the Live Greater View, a financial planning podcast produced by VLP Financial Advisors that discusses life, money, and perspective. We help clients live their best life at every stage through our VLP Live Greater partnership process. Thank you for tuning in. All right. Well, thank you for joining us today. Today's topic we're very excited to have is estate planning basics with Donna Fincher. Donna is a estate planning attorney and partner at Donna Fincher and Sotelo, who has offices both in Tyson's Corner and Leesburg. Donna, so welcome and thank you for joining us today. We're excited. This is a topic that comes up a lot. There's a lot of misconception on estate planning and the pieces that you should have in place and some of the things you have to think through. So can you share a little bit about yourself and the firm and some of the work you do?
Absolutely. Thank you so much for having me here today. I'm happy to be here. My firm, Donna Fincher and Sotelo, is a trust and estate firm, and that's the only kind of work that we do. We focus on estate planning and helping families plan for inevitable events of incapacity or death. We help families settle estates when they lose a loved one. So we're just trying to help people through all those difficult times in life.
Yeah, and settling estates is a lot more cumbersome than people think.
Yes, absolutely.
Yeah.
So, when people talk about estate planning, they're like, oh, an estate? I don't have an estate. I don't have a big house and billions of dollars. So what are some of the basic things, that people should be aware of in estate planning that they should have, may not need or should need, that you find is critical?
So estate planning is, really important for a couple of primary events in life, either planning for incapacity or planning when someone passes away. It's important to have documents in place where you get to designate the people that you trust to step into your shoes, manage your day-to-day affairs, whether it's medical or financial matters, but also planning for what happens when you pass away. That could happen to anybody at any time.
Yep.
If you have minor kids, you need to worry about guardians for them. Everyone has some type of an asset. Some have more than others, but everyone has some type of asset. So just walking through the different options for how to get those assets to their beneficiaries and in the right way to try to protect them and not hurt them through the inheritance.
And when should people start thinking about that? I have a 22 and a 19-year-old, and I'm like, you don't have anything. I mean, you got nothing. But they do have documents as it relates to healthcare because now they're adults. And, so what's the time that you find that people should really start thinking about it and doing it?
Yeah, I really think that people of all ages need estate planning. It's just they might need different kinds of estate planning documents depending on where they are in their life at that time. So I do think it is very helpful for young people, maybe even 18 to 20s, to have the basic incapacity documents, powers of attorney and medical directives. Once someone turns 18, their parents don't have the legal right to manage their affairs anymore. So it's a really important document for the kids to have so that their parents can help them if something unexpected happened. As people get older and their life situation changes, they're going to need more type of planning. As they start a family, they'll need to have a will so they can designate guardians. And as they accumulate wealth over time, they may want to have more in-depth planning with trusts and other type of documents.
So you touched on it a little bit. So let's talk about some of the basic documents. When people think of estate planning, they go back to protecting my assets. They think of, as Dan kind of alluded, I'm not these billionaires that have these assets, or even millionaires who have assets I have to worry about transfer. But, like medical directives, having those things, people don't understand that's also part of the planning process. You're telling people what you want. So if you can touch a little bit based on, the difference between the wills, the directives, and then a little bit, on power of attorneys and how those affect things.
Absolutely. So a medical directive is a document that allows you to designate people that you trust to make medical decisions if you're not competent and able to make them for yourself. You will always make your own medical decisions as long as you're capable. This only becomes effective when you're incapacitated. Medical directives often include living wills in them. A living will is a part that says if I'm terminal, no hope of recovery, don't keep me alive artificially. I want you to withdraw artificial life support. That's optional. Some people will include it, some people will not. But I think the most important part is just designating people that you trust to make medical decisions. And it's important to give them an idea of what your overall goals are for medical care. I don't like to have too many specifics in the medical directive because technology changes all the time.
Yeah.
But just expressing the overall wishes of what you would or would not want.
Yeah.
Powers of attorney are dealing with the financial side, and it's really important for people to have powers of attorney, or your family can't help and manage your assets if you can't make decisions. A lot of married couples assume that just because they're married, they automatically have the right to manage the other spouse's financial matters. Well, maybe on some of the joint bank accounts they can, but you can't have one person sell a jointly owned home without the other's signature. So if you don't do a power of attorney and one spouse becomes incapacitated, now you have to go through a court process and go through a formal guardianship proceeding.
And if they don't have joint accounts, if they have a 401k or an IRA, they have no access. So it's, these are important documents.
Exactly. Yeah. So those are critical for everybody. Even if you have a modest estate, I think they're very critical documents. I think at a minimum, people who have any asset should have a last will and testament just to cover the distribution of any of what we call their probate assets upon death. But a lot of people are under the misconception that if they have a will, their will governs how all of their assets are going to pass. And the truth is, you have to look at how assets are titled, whether there are beneficiary designations, and joint ownership is going to pass assets to the surviving joint owner. Beneficiary designated assets pass them to the designated beneficiary. The will only governs assets that are in a person's name without a beneficiary.
Yeah.
So just understanding how assets are passing is critical to having a successful estate plan.
And we see that from time to time where someone gets a will done, they get remarried, maybe, or some life-changing event, someone passes, but they had beneficiaries that were outdated and they didn't change. And this becomes an issue because the will will not cover this.
Exactly.
So it's important not to only, when we get these documents, but to revisit everything you have and kind of take audit and inventory of everything.
Absolutely.
Yep.
Yeah.
So, well, to touch on that, what do you think is the appropriate time, or how often should people, once they've done this, hopefully they've all gone out and done it, what are some of the events that could happen in life and times that they should think about adjusting and updating?
Yeah, that's a great question. So usually, just for normal life events, it's good to review your estate plan about every 5 to 7 years because a lot can change in that time frame. It might be something changes in your family situation. Maybe your kids are older and now they're able to take a role in the planning. Maybe you had very young kids and now they're teenagers and you want to revisit guardians. Maybe the original guardians aren't appropriate any longer. There are always changes in state laws and federal tax laws, and that's something we can't control.
Sure.
So it is good to review from time to time just to make sure that the documents are still carrying out their goals.
Gotcha.
Yeah.
Okay, good to know. So on top of a will, a lot of time people hear this word trust, and they're like, well, trusts are, for fancy people, and I don't necessarily need it. Can you talk a little bit more about, well, one, what is a trust and why should people have it, and what do they do relative to what a will doesn't necessarily do?
That's great. So, yeah, I agree with you. A lot of people say, I don't have enough money, I don't need a trust. And really, there are a lot of different kinds of trusts, and I think people just assume all trusts are the same. So most of the time, most clients can benefit from what we call a revocable living trust. There are irrevocable trusts out there. Typically, we'll do those when we're trying to do estate tax planning, but not everybody needs estate tax planning. So a revocable trust is a great vehicle to provide for how your assets are distributed to beneficiaries upon death. So the main reason people create revocable living trusts is to provide for how your assets are managed for your own benefit during lifetime. It's a great tool to plan for incapacity. If you can't make your own decisions, your backup trustee can manage them for you. But the biggest reason is avoiding the probate court system upon death. So if someone creates a revocable trust and they connect their assets to the trust, which is a key.
That's a key step, yeah.
Then we can avoid probate and really simplify the administrative process for the family. So many people can benefit from setting up a revocable living trust.
Let's touch a little bit on probate, because I don't think people understand what probate means. They think, I got a will, I'm good, but that will just means you still have to go through probate, versus the trust you can bypass that scenario.
Right. Really, a will equals probate, because I do think people have a misconception that if they have a will, they're avoiding probate. But the truth is, anything passing through a will is going through probate. And basically, it's the court-supervised settlement of a person's probate assets. And a probate asset is an asset that is in a person's name alone with no joint owner and no beneficiary. So anything that's in an individual name, there's no beneficiary, will go through a person's will. If they have one, if they don't, the state has written one for them called intestacy.
Yeah.
So then you have to go through the formal court process where an executor has to qualify with the court and go through the inventory and accountings and just the very formal process that is involved. So we try to steer clients in a non-probate way if we can accomplish their goals, and for most people we can. And it's a much simpler, quicker, less expensive way of administering an estate at death.
Interesting. And when people get named as executor, usually it's mom or dad or a friend goes, hey, would you be my executor? And they go, yeah, sure, no problem. And 99% of people have never been an executor or been a trustee. What do you tell those people what that work is going to look like?
Yes. It's funny you say that, because I do sometimes have clients who are concerned about offending one child or another about whether they should be the executor or trustee or not. And I say, well, once they step into the role, they'll wish that you didn't name them in that role. Because all the work they have to do. So, it's basically dealing with a lot of paperwork. So when you're thinking about who you're going to name in those documents, not everyone is a good fit for it, because you're going to have to file tax returns for people. You're going to have to coordinate with financial advisors and CPAs to make sure all the assets are managed correctly. And you're going to have to do a lot of paperwork with titling and making sure money gets to beneficiaries the correct way. So it is a lot of work. Even if we're avoiding probate, we still have work to do. There's never no administration.
Right.
So I don't want people to assume that there's no way to really have no administration. So it's really important that you name people you trust and that can handle paperwork.
Yeah.
Otherwise, it's not a gift to name them in that role.
Yeah. And logistically, does it matter? If you live in Virginia and you're going to name a trustee who lives in or an executor who lives in California, but you have somebody else that also lives in Virginia, could just as well do it. Do you take that into account at all?
We do. There's no requirement that a person, at least in Virginia, every state might be a little bit different, but in Virginia, there's no requirement that there be a Virginia resident executor or a Virginia resident trustee. So I generally would say pick the people that you think will do the best job. Now, if you have someone in Virginia and someone out of Virginia, and they're both relatively equal in skill set, I'd go with the local person, because I think it will be easier for them to go by your house, check your mail, deal with your bills, and
the logistics of it.
Yeah.
The logistics of it, exactly.
And there are some states that have some different requirements, so it's key to understand the states. Florida stands out.
Yes.
If you have a trust, and you have to involve an estate planning attorney at a certain level, so it's key to know what your state requires where you live, and if you move. A lot of times clients move and don't get their trust reviewed or their documents reviewed.
Exactly. That's a question I get all the time, because clients set their documents up while they're here and then they do relocate. We always recommend that they have an attorney in the new jurisdiction review it and just advise whether anything needs to be updated. especially because there are formalities of the wills and trusts may be different from state to state. And it's not that their document won't be valid any longer, but it may be more complicated to administer it in the new state. So it's safer to have someone review it and make sure that it's going to work the way they intended. And tax laws are different from state to state.
Yep.
So maybe if they're in Virginia, we don't have an estate tax in Virginia, but some states do have estate taxes in addition to the federal estate tax with lower exemption levels. So you have to be mindful that the states are going to vary.
And not even that, like Pennsylvania stands out. Pennsylvania has an inheritance tax, not an estate tax. And a lot of people don't understand that. They're like, oh, well, it follows the federal, yes, on the estate, but not on the inheritance. So there's, again, it's key to understand the state and have those things revisited. Yep.
She's talking by experience.
Experience, yes. I was the executor of a Pennsylvania. And yes, I agree. It's not a gift to be the executor or the trustee. So talking about beneficiary designation, you have a 401k, a IRA, or even an individual account where you can put a beneficiary on a TOD. Talk a little about how appropriate, titling. And I think a big one too is, IRA rules have changed in the Secure Act 2.0. If you're not a spouse, there's a 10-year period. We've seen where some trusts have been named. There's some complications, certainly from administration, from our perspective. So can you talk a little bit about the beneficiary titling and what you need to consider?
Absolutely. So retirement accounts are always a tricky asset to deal with because they're tax deferred, and at some point the income taxes will have to get paid. So our general rule is that at a first death for a married couple, we typically recommend the surviving spouse as the primary beneficiary so they can do a rollover. Obviously, there are certain cases where maybe it's a second marriage, blended family, and we have to structure things differently in order to carry out their other goals, but usually a spouse is a good first beneficiary. The secondary beneficiary is a little bit more complicated, and as you've seen, we've experienced exactly what you described, that usually we're going to consider either a trust if they have a revocable trust or their specific beneficiaries. Often my preference is if their children are adults and they're not concerned about them just squandering it day one, we often will have them name their adult children as beneficiaries rather than the trust. We run into the same problem that when a trust is named as a beneficiary, sometimes financial institutions are not always willing to keep it intact as an inherited IRA, passing to the beneficiaries. But the bigger problem, if the trust isn't drafted a certain way, we might lose some of the deferral where we might not even get the 10 years that an individual beneficiary will get. So I am not a fan of naming trusts as beneficiaries.
I like that.
Sometimes we have no choice because it's minor kids, or maybe we've got beneficiaries with special needs and we're trying to protect the money, or maybe really difficult family situations where we have to plan for that. But the rule of thumb is try to avoid the trust if we can for those type of accounts.
We had an experience where the trust, actually it was joint. We had to share this experience, Dan and I, where the trust was named the beneficiary, but there was one beneficiary of the trust, and circumstances, because things got a little challenging, she was actually the trustee but resigned. So now we had an attorney, and this was going to be a scenario where we had a 10-year payout, but it had been better for her to look through because they were within 10 years of age. So yeah, we think certainly have to understand the circumstances if you're going to name a trust, and it's good to, I'm glad you touched on some of those things. Yeah.
And each financial institution is different on how they interpret a trust being a beneficiary.
Exactly.
which is as an attorney, I'm sure you're going, why don't they just all do it the same? Because this is the legal document that we've written, and yet their legal departments go, you name a trust, the trust is the beneficiary, and you're going, no, but if you read through the trust, we've passed it along to these kids in a certain way, or families or charities or whatever, and they go, we're not doing that. We're not going to interpret this document because that creates risk for us.
Yes.
And so we're just going to be as simplistic as possible and go, it's the trust. And what people don't realize is trust tax rates are slightly different.
That's a nice way to put it, slightly.
In a state and a trust, the tax rates are, they're similar in the percentages are similar to individuals. It's just that the dollar amount to get to that level is really, really low. Right. And so you're going, we really want it to pass along to a person, so they're paying at their tax rate. I just find it very odd that each financial institution just does it completely differently, which I'm sure is frustrating for you.
It really can be, and that's why and even if today there's an institution that is willing to do it with the pass-through, a year or 5 years from now, they may not be because policies change. So that's where I try to keep it as simple as we can. Now, obviously, if control is the most important thing, and clients are okay that we're going to pay taxes sooner and at a higher rate, then that might be their ultimate goal. But most clients don't want to pay taxes sooner or higher.
Right.
So they're usually okay going.
And my favorite comment when you're talking to a client about the scenario, they go, "I'll be dead. I really don't care." I go, "Well, that's not a great solution for, your assets," but it does come up from time to time. Yeah.
So you've mentioned earlier there's constant change with rules and regulations at the state level and the federal level. The biggest thing that we see today is the estate exemption is $13.6 million per person, right? Did I get that right?
30, yep.
And people are like, wow, what person on the United States has $13.6 million? You go, well, some do. And so that's the amount that you can pass away or die with and not own any estate tax. Now, under current legislation, that is going to sunset and revert back to probably about $6 million in January 1 of 26. So there'll be a lot of discussion around this.
Yes.
How are you addressing this with this? This could be coming. Yeah. This may not. What do you and the person who has a $6 million estate or $7 or $8 million is going, well, it's at 13.6. I don't need to worry. And now you're going, well, things could change. What should they be doing things in advance of this, or how do they address it?
Yeah, and it's a problem we've dealt with really my entire years of practicing law. The laws have changed. When I first started working, the exemption was only $600,000.
Yep.
Now we're
I remember those days.
$2.61 million. So as you mentioned, it's growing with inflation. At the end of next year, if Congress does nothing, then the current law expires. We're going to go back to old law, which is going to cut us in half. So, that number will be maybe in the 6.5, 7 million range, just depending on where inflation takes us. But that doesn't mean we're going to get to keep that, because they could pass new laws that lower it even further. And there's always bills introduced into Congress on, I don't know if that's going to happen, but we don't have any certainty. So what some clients are doing, and this really depends on how large the estate is and how much they're willing to part with. So this next year and a half is going to be very busy, because people who have very high net worth are going to try to take advantage of these large exemptions while they have them, and they're going to make large gifts into whether it's gift trust for kids or what we call a SLAT for benefit of spouse. It's an irrevocable trust that benefits a spouse, but trying to use up these large exemptions while they still have them. It's people that have more modest estates. They're still large, but they're more modest. Is how much are they willing to give up, and they may not be as comfortable making those gifts.
Gotcha.
So it's just conversations we need to have with them to figure out what their comfort level is and if it's worth making these gifts at this stage.
And the other challenging thing I'm sure you see is, when they make changes in the law, that's great, but then there's really no guidance or interpretation exactly how that's going to happen. I mean, the 10-year beneficiary distribution for non-spouses and IRA is a perfect example. It's been around for almost 3 years, but we just got final guidance from the IRS. So, that's the struggle that's why it's important. Again, you need to check in, have these documents reviewed, and discuss your estate as things change.
Absolutely, very important.
So one of the other things, there's a lot of online estate planning services. So let's talk a little about that. Because I think you've covered a lot of things where there's this misconception about probate, about will. And I think the biggest drawback on some of these online services is, one, you can't walk through there's no person to go through with your specific scenario. And in some cases, it's a great start to have that other than nothing, but just give a little bit of insight on when these might make sense and when you need to think about where you would you would engage with a estate planning attorney.
Yeah, I'm not familiar too much with some. I know that there's a number of them out there, and they keep growing all the time. I see advertisements on television with them all the time. And there might be some cases for very basic situations where it's better to have probably something than nothing. I don't know the quality of the documents coming out, but at least hopefully it's some protection. But the problem with the online is that you're not having, as you mentioned, the back and forth, the questions. You're not evaluating the family situation, because I think that's one of the biggest variable in what clients should set up for their family. A software program isn't going to ask them those relevant questions and have the back and forth to talk about pros and cons of one method versus another. So, I would say probably most people benefit from having that discussion. Maybe not everyone needs that level of planning, but I think a lot of people would benefit from it.
Not only that, I'm sure when you're having the discussion, we see it here. We are talking about sensitive areas with people when it comes to death and taxes and money. And those are some of the areas. It's just the body language. You could see the look. You can see them, change, and that's where you can maybe probe a little. Okay, I think I've hit a nerve. Tell me why this might be a concern.
Absolutely.
Because I do think that, again, as you mentioned, some basic things might be better than nothing, but it's still important to understand what you're putting together. And with all the states being different, it could be a challenge. Yeah.
Absolutely.
So what are some of the challenges you've seen in family dynamics and having these conversations, right? What we run into is sometimes the kids, the adult children are our clients, and they're trying to get their parents to tell them, well, do you have documents? Where are they at? Because if you can't find them, it's like not
having them,
right? Yeah. And people want to squirrel it away somewhere and keep it hidden. And it's a lot of it is generational. Older generations go, we don't talk about money, even though you can't say a number that I've never been able to count to. What are some of those dynamics and some of the things that you recommend people start doing to have these conversations? It's usually, the adult children with their elderly parents and trying to figure out, well, what's going to go on? What's happening?
Right. I do generally recommend, especially for adult children, that there's some communication with them. Some clients are not comfortable sharing all of the detail. I think the biggest thing is just managing expectations of how things are going to be structured, even if they don't give them every detail. Who is going to be the primary trustee or executor, so that if there's not tension amongst the siblings when that time comes and the person who thought they were taking care of it is not that person.
Right.
So it's more about managing the family relationships and trying to make it as smooth and an administrative process as they can. So I am a fan of sharing information, but I do agree with you that older generations are not as comfortable with sharing that information. But at a minimum, it's important for clients to organize their information and let their family know they've done the planning, where originals are being held, who are the advisors they're working with who will have a lot of information. So we typically will give our clients organizers where they can hopefully fill it in, update it periodically with all the relevant information. I mean, something as simple as what's the password to get into their computer, which is where they're storing all their files.
Right.
We used to just wait for the mail to come when everyone did everything by mail, and after a couple of months, you pretty much have the whole picture. That doesn't exist anymore.
Right.
So you have to create the trail for your kids, or you're going to create a nightmare for them.
Yeah.
Yeah. And do you think those physical documents should be shared, at least a copy of them, with whoever they've named as the power of attorney, executor, or trustee, or is it just, hey, this document is here, and when the time comes, go find it?
That really, to me, depends on their family dynamics. For a very harmonious family, I think sharing the documents is a good idea. Often, clients will get electronic copies of their documents, and they can just email it to their kids. And I do find if you hand hard copies, they're going to get lost over the years. So sometimes doing it electronically is a good way.
Yep.
So for families that get along well, I think that's a great idea, and that way everyone has the information they need from day one. Some families are a little bit have a lot more tension and dysfunction in them.
Yep.
And sometimes that might just open a can of worms. So I think letting the family know the planning is done and where to find them, and the person who's primarily in charge, they need to know that they're the one in charge so that they can go to the house and find everything when the time comes. So I think it's really more case by case depending on their family.
Yeah, this is great. Well, I just want to ask one thing. I see these things on movies, and it's the reading of the will.
Yeah.
And I'm like, I've never heard of this ever. Who does this? And they're all sitting around waiting to see what they get. And
Who got the lake house?
One's disappointed, and the dog got everything. And there's even commercials with it, I think. Does that really actually happen in real life?
I've done this for 34 years, and I've never seen a will. I think that is purely in movies.
Okay.
Got it.
That's what I thought. All right.
Right. And hopefully, I mean, especially this, they should have trust. So
That's right.
it's usually those
They need
situations.
trust.
They need a trust. Yeah.
Exactly.
Oh, well, great. Well, thank you. It's been, Dawn, this is some great information. Thanks for spending your time here today and for joining us. If if you're interested and want to learn some more information, you can reach out to Dawn and her team at Vaughn, Fincher, and Sotelo. And your website is?
Yes, it's www.vfspc.com.
Yep. So you can certainly reach out, schedule some time to have a discussion there, which would be time well spent. We think so. And if you find this, there's a lot of stuff to unpack in this conversation. We covered a lot of topics. Again, this is just scraping the surface of estate planning. But if you are interested in this or other topics, please reach out. You can find us at vlpfa.com. And if you enjoyed this, please share this with your friends and family. And thank you again.
Thanks a lot.
Thank
Appreciate
you so
it.
much. It's been a pleasure.
Thank you for listening to this episode of the Live Great Review. If you like what you heard, please subscribe to our podcast on iTunes or Spotify and recommend our podcast to family and friends. To learn more about VLP Financial Advisors, please check out our website at vlpfa.com. Thanks again.
And now for our necessary disclosures. Securities and advisor services offered through Cetera Advisor Networks, LLC, member FINRA SIPC, a broker-dealer and registered investment advisor. All investing involves risk, including the possible loss of principal. There is no assurance that any investment strategy will be successful. The views stated in this podcast are not necessarily the opinion of Cetera Advisor Networks, LLC, and should not be construed directly or indirectly as an offer to buy or sell any securities mentioned. Due to the volatility with the markets mentioned, opinions are subject to change without notice. Information is based on sources believed to be reliable. However, their accuracy or completeness cannot be guaranteed. Past performance does not guarantee future results.